Hello everyone. So for today, we will discuss about PIPEDA or Personal Information Protection and Electronic Documents Act. So for today's webinar, we will know how does the law applies and what are the rights of the data subjects. And also we have an irresistible offer on how to be compliant with PIPEDA at the end of this webinar. So stay with me in a couple of minutes and learn more about PIPEDA. So I am Mabel, a Certified Data Protection Officer and currently working at the Digital Defender Cybersecurity IT Solutions. So we have authority and experiences from Philippines, Singapore, USA, Canada, and Europe. So our company is dealing with cybersecurity and data privacy since 1973. So PIPEDA became a law last April 13th. So it is to promote consumer trust in electronic commerce. So the act was also intended to reassure the European Union that the Canadian privacy law has adequate to protect the personal information of European citizens. So PIPEDA applies to private sectors across Canada that collects, use, or disclose personal information in the course of commercial activity. So the law defines a commercial activity as any particular transaction, act, or any regular course of conduct that is of a commercial character. So including the selling, bartering, or leasing of donor, membership, and other fundraising list. So the Personal Information Protection and Electronic Documents Acts give people the general right to access with their personal information held by businesses subject to this law. So there are some provinces like Alberta, British Columbia, and Quebec. They have a private sector privacy legislation that may apply instead of PIPEDA. So PIPEDA does not apply to companies that operate entirely in the provinces, where, as I said, local statutes have deemed to be substantially similar to PIPEDA. However, the PIPEDA applies if the data is transferred across provinces, lines, or national borders. So what is not covered by PIPEDA? So there are some instances where PIPEDA does not apply. So some are personal information handled by federal government organization listed under the Privacy Act. So there are some provincial or territorial governments and their agents, business contract information such as employee's name, title, business address, telephone numbers, or email addresses that is collected, used, or disclosed solely for the purpose of communicating with the person in relation to their employment or profession. So there is also some individual collection, use, or disclosure of personal information, like example, personal greeting card list. So there's also some organizations collection, such as to be used in journalistic, artistic, and literary purposes. Remember that municipalities, universities, schools, and hospitals are generally covered by provincial law. So PIPEDA may apply in certain situations. Here are some of definition of terms that you will hear all the time if you are talking about data privacy laws, PIPEDA. So here is, first is we have processing. So it is any set of information or operations performed upon personal information, including but not limited to collection, recording, organization, storage, updating, or modification. So next is we have access. So it is a personal authorized to access personal data. So purpose of the access, mode of access, request for amendments of personal data. And next we have data subject. So here are the individuals whose personal, sensitive personal, or privileged personal information is processed by the organization. So next is we have custodian and processor. So custodian is the one who controls the processing of personal data, while the processor is the one who processes the data or keep the data. or the processor only follows the custodian to what he wants or they want to do about the information. So next we have personal information. PIPEDA protects personal data that contains any factual or subjective information, recorded or not, about any identifiable individual. So this consists of not only personally identifiable information, PII, such as name, age, ID number, and medical records, employees' files, but also it includes opinions, evaluation, comments, social status, and disciplinary actions. So now we will come to the rights of data subjects. First is we have right to be informed. So we have to make sure that the data subjects are informed about the policies and practices. So once we said that we will use it in a certain campaign, so we have to be true with our words. So next is they have the right to object. So it means that if they doesn't like their details to be involved in your system, they always have the right to object and say no. And after objecting, they also have the right to erasure or blocking. So you can once the campaign or the marketing campaign is done, we have to make sure that we have procedures on how to properly erase or delete the information of those data subjects that they doesn't want their information to be out in any campaigns that we have. So next is the right to access. So when we keep a record, data subjects should have the right to access or check the informations that we have. So it is to make sure that any details that we holds or the company holds about them or about the data subjects is always correct. So every data subject should have or can practice this right to access. Because if there's any correction, they have the right to correct any mistakes like misspelled of names or wrong information that they have in your system. And if they applied to or they send you a mail regarding to remove their details or to correct any mistakes or misspelled in their names, and the company didn't comply, so the data subject have the right to complain. So what they need to do is they have to send a letter or they can write a form and address it to data protection officer, and they can state what is the problem and what are the reason they are complaining. And if the company didn't comply or didn't make any steps to contact you or to do the right thing, so you have the right to damages if proven that the company or the organization where your personal data didn't comply or didn't do the necessary things, or it costs you damages with that wrong informations. So question is, can the company deny my rights or request for access to my personal information? The answer is yes. The law sets out a number of exceptions to your general right of access of personal information. For example, there are some circumstances which the organization may choose to withhold some or all your personal information. There are some circumstances that are forbidden by law for releasing the information. So it all depends on what situation that you are currently facing. Here are the implementing data privacy and security measures that we can practice if we are dealing with any data privacy law. So we have three aspects that we should concentrate on. So we have organizational, physical, and technical. So organizational, this is where we have to make sure that all our employees are advised or know how does the PIPEDA works. So next is we have the physical. Physical aspects is where if we have guards, we have to make sure that if they are collecting personal information, it is always kept hidden and not in the eye of the public. So we have also CCTV cameras. If we have to make, if we are using them, we have to make sure that any employees, guests knows that they are being recorded. And the last thing is we have technical aspects. So here comes the antiviruses and VPNs. So we have to make sure that we will not go for free. So at least we need to pay something to make sure that the keeping of files is always safe and secured. So if we also have, we have to make sure also that we have BYOD policy. So what is that? BYOD is bring your own device policy. So we have to make sure that all the laptops, cell phones that are connected to the company, we have to make sure that they are all safe and it cannot be accessed by anybody. So what are the responsibilities under PIPEDA? So first is we have accountability. So we have to make sure that the data collected is safe and secure. Use only in the agreed reason of collecting the information. So let the data subject practice the rights. So next is identifying purpose. So before we start collecting PIIs or personally identifiable information, we should already have a plan in place. So where to use it, till when you will retain the data, and processing of deletions. Next is we have to consent. So we have to make sure that when we process the data, it should always have the consent of the data subject. So we cannot put a data in a certain campaign or a certain information in a certain campaign without the consent of the data subjects. So limiting collection. So in here, we have to make sure that you have a specific plan about the information. And also, you should only collect the information or details that you needed. So we have to practice proportionality. It is that is very important that if the details is not needed anymore, you have to delete it immediately. So we have to remove this mentality that we will use it for future use. So most companies face huge fines because of this mentality, because they fail to delete some information that is already due. So again, limiting use, disclosure, and retention. So next responsibilities is accuracy. So we have to make sure that the details we have is always updated. So one way of doing it is like we can send our clients to fill up a form regarding the details. So they can, and we have to do the changes as soon as possible. So next is safeguards. So we have to make sure that we have the right tools in order to avoid data breaches. And breaches can cost millions of fines. So next is openness. So transparency is very important to gain the trust of any customer or clients that you have. So once you violated, it can cause loss of clients or penalties for violating the rights of data subjects. And we have individual access. Of course, we should allow our clients to have the access of their personal data. Sometimes as a clients, we want to make sure that, that the details that the company has about us is always correct and updated. So it can ease our mind. So next thing is challenging compliance. So with regards to complying with PIPEDA, we should always continue privacy, or we should always have privacy impact assessment. We should update our privacy manual and systems, and of course, continuous lectures or seminars to our employees and be aware of the PIPEDA and how it affects our business. So one of the major new requirements brought by PIPEDA was the introduction of mandatory data breach. So as of November 1st, 2018, organizations must submit to PIPEDA or must notify that the Privacy Commissioner of Canada if they become aware of any breaches of security safeguards, including personal information that pose a real risk of significant harm to individuals. Organization must now keep records of all breaches of security safeguards for 2 years. So whether these breaches were reported to the Privacy Commissioner of Canada or not. So companies will need to develop a framework to assess the real risk of significant harm. If an organization knowingly disregarded the new PIPEDA requirements of data breach notification and recording keeping, they can face fine up to Canadian dollar 100,000 for each violation. In any data privacy law, on how to process the data or information is very important. So we need to know where are the possible aspects that a breach can happen. So as I said earlier, we have organizational, physical, and technical aspects to pay attention to. We, the digital defenders, have been in the industry since 1973, and we are here to help you. So here are the services that we can offer that can help you be compliant with PIPEDA. So one of the services that we have is we can conduct a privacy impact assessment. So we have the right tools to make sure that there are no possible holes that you may encounter in processing the information. So for only $1,997, we can help you predict and prevent breaches that might happen in processing your information. Another service that we do offer is to help you with your privacy manual. So what is privacy manual? If you have a lot of employees in your organization right now, having a privacy manual will help you make sure that all your employees will be knowledgeable with all the process that you have, especially in collection, use, storage, transfer, and deletion of personal data. And also, you will know who are the right person to do the manual. So for these services, we can offer you $1,447. So once you take this offer, we will guide you with the step-by-step procedure on how to make the privacy manual. Next services that we have is, which is one of the important aspects of data privacy law. So it is managing your breach. So do you have a security incident response team? So what are the things they need to do if there is a breach? So in these services, we can guide you or we can guide your team on how to report any breaches that they will encounter. So our offer is for $1,497 only. And lastly, we can also certify and train your assigned data protection officer or personal information controller. So for only $997, we can train and certify your custodian to make sure that they will know the full process on how to be compliant with the PIPEDA. Plus, with this offer, we have a special promotion of having a free 6 months consultation to guide you with the process. So better start your compliance now. So this is the end of my webinar. If you have more questions, you can set an appointment with us. Just kindly scan the QR code that you can see in the screen right now. And also you can download your free gift in that QR code. So this is Mabel from the Digital Defenders, and